Hearing the appeal, Duval, against 11 to 13 Randolph, Crescent.
Good morning. Before we begin, we should mention that 3 of us live in London flats. In my own case, I checked the lease last night, and it does contain clauses pretty similar, but not identical to the ones with which we're concerned. But as with the property with which we're concerned, this is a block which is owned by the leaseholders, and so we are both landlords and tenants, so it seems to me there's no conflict there. We just thought we ought to draw it to your attention in case you feel any sort of concern about it.
Just take brief instructions, my lady.
Say that being in the same boat as your ladyship, we have no objection whatsoever to the court deciding that, even if they do live in London flats.
Of course, my lady, we have no objection either.
Thank you. We just thought we'd better raise it.
Yes, I mean,
we didn't ourselves think it was a matter
No.
for recusal, but we would not have wanted you to go away and think, oh, I wonder how many of them.
No, we're very grateful for that indication. Thank you very much.
And some of us are not both landlords and tenants.
Thank you. My ladies, my lords, I appear with Miss Murphy for the appellant and Mr. Morey, Queen's Counsel, and Mr. Mallet appear for the respondent. The question for the court, as you know, relates to the interpretation of a lease or a series of leases in a block of 9 flats in Maida Vale. It doesn't have the dramatic scope of some of the questions with which this court is asked to deal, but it is of very significant practical importance for many thousands of residential lessees who occupy under the same terms as are in issue in this case.
Can I ask you, does
Yes, of
that?
course.
I mean, we're told it is of great importance. On the one side, we're told this is absolutely standard and everyone's always thought as a court of appeal did. On the other side, we're told it's enormous importance.
Yes.
But we haven't got any sort of articles, or there hasn't been an outcry in the Estates Gazette or anywhere, has there?
My lord, you do, in fact, in the authorities bundle.
Well, you'll come.
So I will come to that, but just to answer your lordship's question, we very strongly take issue with the assertion made at the beginning of the respondent's case that somehow the Court of Appeal's decision was orthodoxy restored, as it were. That doesn't reflect case law, it doesn't reflect academic writing, it doesn't reflect the experience of those of us who practice in property law on this side of the court, and it doesn't reflect the tenor of the practitioner commentary which has been available since the Court of Appeal's decision. We have included some of that in the bundle.
I'm sorry, I haven't looked at it.
No, it's not referred to in the written case, and it isn't put forward because it's of high academic worth in order to enable your lordships to decide the question, but merely to demonstrate that the tenor is that the Court of Appeal's decision has far-reaching and unforeseen consequences. And I would, in that respect, particularly ask the court to note one of those articles. It's in the Property Law Journal. It's at page 1374 of the electronic bundle. And I should say that the hard copy bundles are also paginated in the same way, which is Authorities 3, Volume 3, Tab 27. It's written by a solicitor, David Harris, at Brown Jacobson LLP. And it deals in some detail with the practical difficulties which are seen to arise as a consequence of the Court of Appeal's decision. I'm proposing to take your lordships and your ladyship to that unless you'd like me to, but that is
And this is
a
written
useful
when?
source. I'll let you. June 2019.
I see. Okay. Thank you very much. That's very helpful. Thank you.
Does it have any commentary upon the decision itself, or is it just a summary of the decision?
It has a commentary, my lord. So if I take your lordship to it, it's the last tab in volume 3, or as I said, page 1373 and 1374 of the electronic bundle. And the first pages are an explanation of the decision. But if I go to electronic bundle 1376, you'll see there's a heading that starts implications of the decision for landlords. And then it continues from there, implications of the decision for tenants. It's those sections really which provide a commentary on
Yes.
the author sees maybe the consequences for the Court of Appeal's decision. And for your Lordship's note, the other practitioner commentary we've included is also in this third authorities volume. Some of the pieces are very brief. There's not a lot of detail in the others, but at tab 19, which is page 1323, there's a little section from Aldridge on leasehold law, which makes brief reference to the unforeseen implications of the Court of Appeal's decision.
Sorry, what was 1323?
1323, my lady.
Thank you.
And the passage in question is where?
In Aldridge, it's at page 1326, right at the top of the page. Then in the Estates Gazette, tab 25 in this bundle, electronic bundle number 1365, has a short case note by Elizabeth Duomo, a barrister, at page 1368. And really it's the heading, or the subheading, where it said she discusses a recent decision that potentially has far-reaching consequences for leaseholders and their ability to renovate their properties.
Thank you.
In the following tab at page 1369 is an article by Raymond Cooper, which the heading, the title might tell you everything, Duval and Worse, How to Make Management of a Block of Flats Impossible. I should say it is particularly concentrating, however, on the consequences of entering into a letting scheme. So saying that that's even worse than the Duval decision.
Sorry, could you just give me the page reference to that one?
Yes, it's page 1373. Sorry, my apology. 1369. I don't want to place undue weight on those. Many of them are just summaries of the case with a little bit of commentary. The Property Law Journal one has the greatest, the most extended discussion of the consequences, but they reflect the tenor of the practitioner commentary and demonstrate that this is not just normal service resumed, as the respondents have suggested. My ladies and my lords, where a building or estate is occupied by a number of leaseholders, there are three models, or three main models for the enforcement of the tenant's covenants. The first is a letting scheme, and that involves a reciprocal scheme under which each tenant can enforce their neighbour's covenants directly against their neighbour, at least the restrictive covenants in their leases. It's a form of local law. These letting schemes are occasionally to be found, particularly set up in the 1960s and 1970s, and the Arnold and Britton case involved a letting scheme involving holiday chalets. They are very uncommon in a commercial setting, although my Lord Carnwell dealt many years ago with a parade of 5 shops that were subject to a commercial context letting scheme. It's Williams and Kiley, it's in the bundle, but it concerned five shops that were let on a letting scheme. The second model is the one that we have here, where the covenants create a legal relationship only between the landlord and the individual tenants, but the tenants are given the right on certain conditions, such as payment of costs and provision of security, to request the landlord to enforce the covenants in their neighbours' leases. And that model is very common in a residential setting. The respondent has suggested that virtually all residential leases contain such a covenant. We think that's putting it a bit too high, but it's undoubtedly a model with widespread use across England and Wales. and that is less frequently found in a commercial setting. And the third model is one where the enforcement of covenants is entirely a matter between the landlord and tenant, and the other tenants have no rights to require enforcement. In those circumstances, the other tenants are reliant on their common law rights and on the landlord's commercial interest in having a properly managed building estate. And that's the most common model for commercial settings. And as your ladyships and lordships know, the question for the court is this: where the model is of the second kind and the landlord has given a covenant to tenant A upon request and provision of security for costs to enforce the covenants in other leases, does the landlord breach its obligations by granting a licence to tenant B to do something which, if there wasn't a licence, would constitute a breach of tenant B's covenants? Or perhaps to put it more simply, with reference to the facts of this case, the particular issue is if Mrs. Winfield applies to her landlord for permission to carry out works on her flat which are otherwise prohibited by clause 2.7 of her lease, does the landlord breach the lease of Dr. Duval by granting that licence? And the Court of Appeal answered that question, yes. It held that a term is to be implied into Dr. Duval's lease which prevents the landlord granting a licence to Mrs. Winfield. Well, Justice Lewison suggested that it might possibly be categorised as a rule of law rather than an implied term, but in the circumstance of this case, he said that would make no difference. We say that the Court of Appeal is right, that the question is whether or not there is an implied term, but it was wrong to say that a term should be implied, that the landlord couldn't grant the licence to Mrs. Winfield. The respondent puts forward a different analysis, which I will deal with later in my submissions. As I've said, we contend that the Court of Appeal decision causes very real practical problems in the management of blocks of flats and other multi-occupied buildings and estates. By way of housekeeping, my lady, my lords, the pagination is the same in the hard copy and the electronic bundle. There are hyperlinks in the indices and references in the written cases in your electronic bundles, but they don't show up as a different colour. They do work as hyperlinks. It's been agreed in the timetable that I should have 2 hours to start off with, and unless you tell me that it's not necessary, I propose to start by just taking you to the key provisions of the lease, and then order my submissions under 5 headings following the order of our written case. So firstly, to look at the contextual factors which we say are important in interpreting these leases and which we say the Court of Appeal overlooked. Secondly, to look at the express provisions of clause 3.19 and explain why we think the Court of Appeal misconstrued it. Thirdly, I'll look at the question of implication and whether this is really a question about an implied term or whether it's a rule of law, and at that point I'll deal with the respondent's alternative submissions. Fourthly, I'd like to explain why it's important to identify the term which is said to be implied with precision and look at the different impacts of different potential implied terms. And fifthly, I'll make submissions on why the tests of business efficacy and obviousness are not satisfied here. So, my ladies, my lords, would you find it useful for me to take you to the key provisions?
Well, I expect so. I'm sure we've all looked at them with some care
Yes.
preparing, but you could at least give us...
Perhaps skip through them.
Yes.
So it's electronic bundle, page 171, core bundle, tab 8, little 7. If we take the front page, what we have in the bundle is one of the 2 leases which was originally granted to Dr. Duval by the Church Commissioners. You'll see it's of 11G Randolph Crescent, and it was granted on the 10th of January 1986. Skipping to page 172, you'll see that the landlord at that date was the Church Commissioners for England, with my client, 1113 Randolph Crescent, being named as the management company. But as we'll see, the scheme was always set up on the basis that my client would acquire the freehold from the Church Commissioners. It was part of the Church Commissioners' sale off of their Maida Vale estate. The term of the lease at the bottom of page 172 is 125 years from the 24th of June 1981. And on page 173, the rents are a peppercorn and the service charge, so the landlord has no income other than the service charges. There's a premium of £75,000, no doubt a substantial amount of money, in January 1986, and the specified user is as a single self-contained residential unit in the occupation of the tenant and his immediate family only. I can take you then, please, to the recitals, please, page 186. And you'll see from recitals D and E that it was always part of the scheme that the tenant would hold a share in my client and that the landlord, the Church Commissioners, would transfer the freehold of the building to my client. Page 187, towards the top, we see the terms of the demise in traditional form. The demised premises are demised together with easements, rights and privileges mentioned in the first schedule, accepting and reserving as mentioned in the second schedule. And if we go to the definition of demised premises, that's at page 178.
Could you give the internal page numbers as well? Because I've got...
Yes, I'm so sorry, my
paginated
lady. Yes,
version.
page 2 of the lease. So the demise premises, the definition starts in about the middle of that page, and it's very detailed. It continues for the next 2 pages, page 180, 181 of the bundle, page 3 and 4 of the lease. And probably for present purposes, the things that it's worth noting are the exceptions from the demise on page 181 or internal page 4. And the exceptions from the demise include, in little 2, the outer and load-bearing walls of the building, and at little 5, columns and beams which are load-bearing or structural. And over the page 182, internal page 5, right at the top, the exceptions include all conduits, which are pipes and cables, etc., and apparatus within but not exclusively serving the demised premises. And the reason for highlighting those exceptions is to make the point that there are elements of the building which are physically within the flat, the load-bearing walls of the building, but which are accepted from the demise. And that issue which has caused particular difficulties in this case because Mrs. Winfield wanted to remove part of a load-bearing wall in order to make her flat more open plan. It includes load-bearing walls which are accepted from the demise. Yes, I'm asked to turn to bundle page 178, internal page 2. And as my learned friend points out, little a and little b also deal with what is within the demise. Within the demise, little a includes all internal walls except those referred to in b below. And little b includes within the demise one half only, severed vertically, of non-load-bearing internal dividing walls, which mutually serve to enclose the demised premises and other parts of the building. And such last mentioned walls shall be deemed to be party walls. So the walls which are internal to the building but divide the flat from the rest of the building are only half demised. They're party walls.
Basically, there's a sort of shell, isn't there?
Yes,
which is within the demise, and then the outer bit of the shell is outside it. It's as if it's a two-layered
yes.
walls, isn't it? Plus the load-bearing walls that are actually wholly inside are accepted.
We sometimes talk about an eggshell tenancy, which is simply the external surfaces of walls. This demise is actually further because
It's
it
further,
includes half. It's a party wall situation on the external parts of the demise. And I should perhaps point out at page 180 in the bundle, internal pagination 3, towards the top, little c, the demise includes the internal surfaces of external walls and load-bearing walls. So it's not quite an eggshell tenancy, but it is a tenancy which is not unusual, where the structural parts of the building are not all demised, even though they are physically within the flat, and some of the conduits, that is to say pipes and cables, ducts, etc., insofar as they serve other parts of the building, they are not demised, even though they might be physically located within the flat.
Is there a plan anywhere of what was wanted originally in the big plan that caused the litigation?
Not in the bundles, no, my lady.
It would be very helpful to see how it actually fitted into. We've got a plan in here of the block.
Yes, yes.
Because it was inside, but it was load bearing. Is that
Yes.
That's the issue?
That's right, inside and load bearing. I'll certainly see, my lady, what we can do. I don't recall myself having seen anything in the original evidence, indeed.
No.
Giving that amount of detail, but I will see what we can do to help enable you to imagine the work.
Yes. No, I was wondering about it really in conjunction with 2.7, because that's to do with the demised premises.
Yes.
And if this is a load-bearing wall inside, it's not demised.
No, that's right, my lady, but clause 2.7 is not confined to the demised premises. So
Yes, I see.
it's one of the, it's actually a very common form of clause, but it's a covenant which affects both things which are within the demise, roofs, walls or ceilings which are within the demised premises, but it also includes things that are outside of the demise, including roofs, walls or ceilings enclosing the demised premises, and it includes all sewers, drains, pipes, radiators, ventilators, wires and cables therein, whether they are demised or not.
Okay.
So it's a sort of portmanteau covenant that affects not only what the tenant can do within their demise, but also what they can do outside of their demise, to a certain extent.
Yeah. So was this a roof, wall or ceiling? Or?
It's a wall.
Right. Okay.
It's always been common ground, and your ladyship's question is an interesting one. Was the wall, would the wall properly be described as within the demised premises, given that the internal surfaces of the wall would have been within the demised premises, but the actual load-bearing structure of the wall was accepted from the demise? I think that would be
Yes.
inquiry. I have to say that the litigation has always taken place on the basis that the works that Mrs. Winfield wanted to carry out would fall in part within clause 2.7, as well as requiring licence under clause 2.6.
Thank you.
So, for completeness, if I can, you had a look at what's demised, if I could take you to the schedules which show the easements and rights which are granted and reserved. Electronic bundle number page 207, internal page 30. It's the first schedule. This shows what is included in the lease. And over the page, at page 208, internal page 31, you'll see that there are a number of rights included with the lease. They include, for example, under 2, rights of way and passage, for the purpose of obtaining access to and egress from the demised premises. At 4, the free passage and running of water, soil, electricity, etc., through conduits as passed through the building. 5, the right to subjacent and lateral support and to shelter and protection from adjoining premises as now enjoyed by the demised premises. And then the second schedule starts a little bit further down that page and accepts from the lease various things, including at 1, the free passage and running of water, etc., through the conduits as passed through the demised premises. At 2, full power and liberty to build upon or otherwise deal with any adjoining or neighbouring land or property belonging to the landlord as the landlord may think fit, notwithstanding that the access of light or air to the demised premises may thereby be obstructed or diminished. And we see a similar right to subjacent and lateral support and to shelter and protection from the demised premises enjoyed by buildings now or hereafter to be erected. And if we go to the tenants' covenants, please, we have a look at clause 2.6 and 2.7, electronic bundle page 189, internal page 12. A brief look at 2.7, which is the clause of particular issue in this case. But 2.6 is also referred to by way of contrast, because that allows, it's a covenant not without the previous written consent of the landlord to erect any structure, pipe, partition, wire or post upon the demised premises, nor make or suffer to be made any alteration or improvement in or addition to the demised premises. So that is a qualified covenant, qualified by reference to the ability to obtain the previous written consent of the landlord, in contrast with 2.7, which is an absolute covenant not to commit or permit or suffer any waste, spoil or destruction in or upon the demised premises, or cut, maim or injure, or suffer to be cut, maimed or injured any roof, wall or ceiling within or enclosing the demised premises, or any sewers, drains, pipes, radiators, ventilators, wires and cables therein. It's a reference to not to obstruct casings or coverings of conduits.
Is there any guidance on what is meant by cut, maim or injure? I mean, presumably it doesn't include hammering a picture hook or something like that. I mean, there's obviously limits to what sort of cutting is involved.
Yes, my lord, it's a very, very ancient right. The fact that it's referred to as waste, it was a medieval tortious action,
Yes.
waste. Yes, there is a lot of authority about what constitutes waste, which would include alterations that a tenant would consider to be beneficial to them. So although it sounds pejorative, waste, it includes all forms of changes and destruction or cutting into, even if the end result is a beneficial one.
So, I mean, it'd be quite helpful. Have we got that in the papers? Referred to Woodfall or something?
I don't think you lordships have, and we'll see what we can do to point you in the right direction.
Not a lot of cases, but it does seem,
Yes.
if it's a standard thing, the passage of
Yes,
Woodfall or whatever.
yes, there will certainly be discussions in Woodfall.
Thank you.
If you could just make a note of that. Thank you. That for you. Then, if I take your lordships, please, to page 192 of the bundle, internal page 15. Clause 2.10.4, headed tenant's share, includes provisions for essentially ensuring that the share in the landlord, my client, the management company, travels with the lease. So there are detailed provisions to ensure that that happens. Then, if I take your lordships to page 195, internal page 18, down at the bottom of the page, clause 2.14.2, headed licence/consent fees. the tenant covenants on any application to it by the tenant for any licence or consent in connection with this lease, and for preparing any such licence or consent, whether or not the tenant shall take it up. Sorry, I didn't read the opening part, it didn't make sense. At 2.14, it's to pay to the landlord all the costs, charges and expenses incurred by the landlord on any application to it by the tenant for licence or consent. And what we say is of interest here is that this clause uses licence as well as consent, whereas the qualified covenants that the tenant gives use only the word consent. So if we look back at clause 2.6, which is at bundle page 189, internal page 12, you'll see that 2.6 is not without the previous written consent of the landlord. Equally, if we turn to page 191 of the bundle, internal page 14, this clause 2.10 deals with alienation, and clause 2.10.3, which is headed landlord's consent, says, without prejudice to the absolute prohibitions hereinbefore contained, not to assign or underlet the whole of the demised premises without the prior written consent of the landlord, such consent not to be unreasonably withheld. So it's part of our argument that clause 2.14.2 recognises a concept which is not just a consent under a qualified covenant, but a licence. And we'll have a look at what that means against the statutory context in a moment.
Did Lord Justice Lewison say anything about that point?
No, he didn't deal with this provision. He did refer to the statutory provision, which is in section 143 of the Law of Property Act. Then, my Lords, if we turn to page 198 of the bundle, internal page 21, see the heading Regulations in the middle of the page. This is the tenant's covenant to observe and perform the rules and regulations set forth in the 5th schedule, and such additions and amendments to those rules and regulations as the amenity company and or the landlord. Just pausing there, the amenity company controls the gardens, the communal gardens. And or the landlord may reasonably from time to time make for the safety, care or cleanliness of the estate, the building or any part thereof, or for securing the comfort and convenience of all tenants therein. And then the provisos set out essentially how tenants are to be made aware of what is the up-to-date set of regulations that is made in that respect. The original regulations are in the 5th schedule, which is at page 217. Internal page 40. The sorts of things that you would expect to see in terms of ensuring that there's neighbourly conduct maintained in the building, not playing loud music, essentially not hanging out your clothes outside the demised premises, and that sort of thing. It goes on for 2 pages, the 5th schedule, 3 into the 3rd page, in fact. But as we've seen from clause 220, the landlord can unilaterally amend those regulations, and there are provisions made for how those amendments are to be publicised so that everybody knows what the terms are under which they must occupy. And then in the landlord's covenants, I take your lordships to page 204, internal page 27. Clause 319 is obviously the most important of the landlord's covenants. That's the one that is particularly in issue in this case, and I'll come back to it and look at it in more detail later in my submissions. But your lordships and ladyships should also note clause 3.18 headed as to other parts of the building, just above clause 3.19. I have to say that as drafted, it's a bit garbled. One can understand the gist of what the drafters were trying to get at, but parts of it don't make complete linguistic sense. What your lordships and ladyships may find helpful to do is to break it up into 3 parts, so that the first part reads, in respect of any other part or parts of the building, and during such time that such part or parts is or are occupied or demised on terms which do not include provisions equivalent to those contained in this lease, and on the part of the landlord and the tenant thereunder to be performed and observed. So that's the stop, that's the first part, that explains what parts of the building this provision is intended to relate to. And the next part is to provide services and pay the service charge, ensure, repair, decorate, maintain, and so far as reasonably possible, comply with and enforce provisions as to the user of such other part or parts and other provisions of this lease. And then perhaps that's the next stop. That's what's to be done. And the last bit of the covenant relates to why, for the benefit of the tenant and other occupiers of the building, as though the covenants contained herein had been included in the demise or terms of occupation of such other part or parts of the building. Now, some of that makes sense. For example, let's assume one of the flats is let on an assured short-hold tenancy. Yes. Then it makes sense that the landlord will be responsible for paying the service charge, as if it were one of the flat owners, the long leasehold flat owners, that it would be responsible for insuring and repairing or decorating that flat. What's more difficult to understand is how the landlord is supposed to enforce, even so far as reasonably possible, provisions of this lease, as though the covenants contained herein had been included in the demise or terms of occupation of such other part or parts of the building, in circumstances where the beginning of the clause tells us that those parts haven't been demised on the same terms or on provisions equivalent. Obviously, the landlord can only enforce whatever terms it has in fact agreed.
Comply with makes more sense.
Comply with makes more sense, my lady, absolutely.
It's probably a pretty standard sort of clause to deal with blocks of flats where you've got a mixture. Some long leases, some assured short hold, some even hanging on from statutory tenancies or whatever. Yeah.
That's right. And as I said, there are parts of this which you can understand how it works. That the landlord, if it's got a caretaker in a flat, for example, yeah, the landlord takes responsibility for paying the service charge, insuring and repairing, as if it were the holder of a long residential lease. The concept of enforcement, I would suggest, is a little difficult to understand how that is intended to work. But that's not the clause that we're particularly concerned with. So, my lords, my ladies, that's a sort of whistle-stop tour through the key provisions of the lease. Is there anything on that document I can assist you with? Shall I move on? Thank you. So, my ladies, my lords, I turn to the first part of my submissions, which is about the context in which these leases fall to be construed. And this relates to our written case, paragraphs 13 to 29, starting at page 79 of the bundle. And There
You
we
can
list
assume
out...
that we have read your written.
Yes, yes, indeed, my lady, indeed. Would have seen that we list out 7 contextual factors which we say the Court of Appeal overlooked, or to which it gave insufficient weight, both in construing the express terms of these leases and in considering whether or not it was appropriate to make any implication. And I certainly don't want to repeat what's said there, but I do want to draw together a couple of those points, and I also want to address a contention made by the respondent that it's impermissible to place much weight on these contextual factors because the leases are public documents. I'd like to deal with that submission. But to draw together some of the points made in our written case, at the heart of these leases is a conundrum, essentially. What we have in each case is a lease for a long term, for 125 years. And we all know that a long residential lease is not just a contract, it's a valuable capital asset, and it's usually somebody's home. We also have within it a clause 2.7, which imposes an absolute prohibition on doing things that would inevitably need to be done during that period of 125 years if the flat is to retain its value as a capital asset and it's to remain suitable as someone's home. Clause 2.7 captures a range of different kind of modernisation works. Some of them are really quite minor. It would capture rewiring, it would capture replacing radiators, it would capture putting in an extractor fan into a kitchen, changing the layout of a bathroom, putting in recessed lighting. So it's important to bear in mind that clause 2.7 is not just about structural works, although it would capture structural works. And as I've already submitted to my Lady Black, it's not just about works outside the demise, although it includes some works outside the demise. So when the Church Commissioners and Dr. Duval agreed those terms in 1986, they objectively knew that this flat would have to be modernised and updated several times during the course of the century and the quarter that would follow. They knew that that up-to-the-minute avocado bathroom suite wasn't still going to be there in the 22nd century. So one has to ask, how can it be that for decades, residential conveyancers up and down the country have allowed their clients and their clients' lenders to hand over very substantial amounts of money for these assets in circumstances where clause 2.7 would appear to say they can't be modernised? We say that the answer to that lies in the conveyancer's knowledge about how landlords and tenants in fact operate. No doubt there are contracts where if one party promises not to do X, the expectation is that X will not be done throughout the course of that contract. But we submit, take that assumption into the world of the long residential lease is to close one's eyes to reality.
Can I just sort of, goes back to the point I was asking, when you say it would affect changing a radiator, that's because that would be cutting or maiming a radiator, which is
Yes.
a slightly odd concept. I mean, is that clear from the authorities you mentioned?
My Lord, that I would suggest is clear from the terms of the covenant itself.
I know it says cut or maim a radiator, but it's a slightly odd concept.
Yes, if one removed a radiator in its entirety, it would be difficult to see that that's anything other than cutting or maiming a radiator. Or one can see...
Yes, no, I mean, you're probably right. And no doubt when we look at the extract from Woodfall or whatever it is, that'll be clear, but and it may be common ground, so don't spend time on it.
I don't think there is anything between the appellant and the respondent about the width of clause 2.7. What we both agree is that it has to be given a meaning independently of clause 2.6, which itself is very apparently broadly phrased and includes any alteration or improvement. The difficulty is that if you read any alteration or improvement to include all of the sorts of alterations which fall within 2.7, you're effectively denuding that of any content at all. So for it to have some meaning, the reference to alterations or improvements in clause 26 must be narrower than any alteration or improvement. It must be alterations or improvements which don't otherwise fall within clause 2.7. One can see, for example, that perhaps taking away an old radiator and putting one back in exactly the same position might not fall within clause 2.7. Taking all the radiators out and replacing them with a completely different kind of heating system, which might well be something that would be envisaged over a period of a century and a quarter, would appear to be cutting or maiming, suffering to be cut, maimed or injured the radiators in the demised premises.
I mean, pipe, the word pipe appears in both.
Yes.
And so your interpretation, as you're urging it upon us, have I correctly understood it to be this, that you look at the scope of 2.6 and that sits with 2.7 because 2.7 covers what is not within 2.6. Is that right?
Other way round is what?
Or the other way around?
My Lord, what if you have a look at 2.6, it actually falls into two parts. It might be easiest to deal with that. So the first part of 2.6 is not to erect any structure, pipe, partition, wire or post upon the demised premises. Now, that's in contrast with 2.7 as regards sewers, drains, pipes or radiators, which are not to commit or permit or suffer any waste, spoil or destruction, nor cut, maim or injure any sewers, drains, pipes, radiators, ventilators, wires and cables therein. So 2.6 seems to cover erections of new pipes. I don't think one would quite describe it as an erection of a new pipe, but an installation of new pipes, wires or posts, whereas 2.7 would appear to be addressing the removal or damage to changing of existing sewers, drains, pipes, etc. But then if we look at the second part of clause 2.6, nor make or suffer to be made any alteration or improvement in or in addition to the demised premises, it would be nice to be able to say, well, that would be great. That would cover any kind of alteration or improvement in the demised premises. It wouldn't include alterations or improvements to property that fell outside the demised premises, but it would at least include everything within the demised premises. Difficulty with taking that position is that we do still need to give some meaning to clause 2.7, which seems to suggest, or does say, that the cutting, maiming or injuring of roofs, walls or ceilings within the demised premises is captured in clause 2.7. So nice as it would be to put as much work as possible in clause 2.6, if we're going to read this lease as a whole and give clause 2.7 some meaning, we have to extract from 2.6 that which falls into 2.7.
Right, thank you.
So just say for the purpose of completeness, there may be other clauses in the lease which would need to be read together with clause 2.7. For example, there's a repairing obligation on the tenant. The question would arise if something that would otherwise fall within clause 2.7 is necessary in order to comply with the repairing obligation. Does that mean the tenant has the obligation to carry it out even though it would otherwise fall within 2.7? Or, for example, if it's necessary to comply with statutory obligations, there one might more readily be able to say that the obligation trumps 2.7 and that the tenant must do whatever is required under its repairing obligation or its obligation to comply with statutory provisions. But where you're just talking about modernisation, refurbishment, things that aren't that the tenant wishes to carry out but isn't obliged to, then it's more difficult to do that. So, my ladies, my lords, I was submitting to you that residential conveyancers understand the world of the landlord and tenant, which is why they allow their clients and their clients' lenders to enter into these sorts of provisions. The first thing that they know is that if they ask the landlord to qualify a clause like 2.7, so to add in a reference to the landlord's consent, it's likely that that will be refused. And that's for two reasons. First of all, the landlord wishes to retain control of its own property, so that which is not demised, it doesn't wish to, wants to retain the control of an absolute covenant over those areas. And secondly, because of the statutory context in which these leases are granted, and in particular, Section 19, subsection 2 of the Landlord and Tenant Act 1927. And could I ask your ladyships and your lordships to turn that up, please? It's bundle reference 565. It's the first volume of the authorities, and it's tab 11.
Did you give us a page which I have?
565, my lady. Subsection 2 is about 2/3 of the way down that page. And it provides, in all leases, whether made before or after the commencement of this Act, containing a covenant, condition or agreement against the making of improvements without a licence or consent, such covenant, condition or agreement shall be deemed, notwithstanding any express provision to the contrary, to be subject to a proviso that such licence or consent is not to be unreasonably withheld. I'm just going to pause there for a moment, just to say there's lots of case law about what Section 19, subsection 2 means, but what is established is that the making of improvements doesn't mean that the covenant has to mention improvements. If a covenant is a covenant against alterations, which would have the effect of preventing an improvement, then it is captured within this provision. And it's also established that the word improvement means an improvement from the perspective of the tenant. And we can see why that is, because the subsection continues, this proviso does not preclude the right to require as a condition of such licence or consent the payment of a reasonable sum in respect of any damage to or diminution in the value of the premises or any neighbouring premises belonging to the landlord. So the provision contemplates that something can be an improvement and at the same time cause damage to or diminution in the value of the premises or any neighbouring premises belonging to the landlord. It's also been held that as a consequence of those words, that the landlord is not entitled to refuse consent on the grounds of pecuniary loss alone to a pecuniary diminution in value to the value of its reversion or to neighbouring premises, that it's obliged, if it wants to claim for that, to make it a condition of granting the licence that the tenant provides compensation for that diminution in value. It continues, and of any legal or other expenses properly incurred in connection with such licence or consent, nor in the case of an improvement which does not add to the letting value of the holding, does it preclude the right to require as a condition of such licence or consent, where such a requirement would be reasonable, an undertaking on the part of the tenant to reinstate the premises in the condition in which they were before the improvement was executed. So the statutory provision applies notwithstanding any express provision to the contrary, which means it can't be contracted out of. The consequence is that if you have a tenant's covenant for alterations, it is automatically deemed to be subject to a proviso that the landlord cannot unreasonably withhold its consent. And that is seen as very substantially limiting the landlord's freedom of manoeuvre, including in relation to property of which it is in possession. Consequently, for landlords, there is a significant difference between an alterations covenant not to carry out alterations except with the consent of the landlord, and an absolute covenant not to carry out any alterations, because the statutory provision turns the first kind of covenant into what we call a fully qualified covenant, that is to say, the landlord cannot unreasonably withhold its consent. So what landlords prefer is to impose an absolute covenant which gives them the ability to grant licences to depart from the absolute covenant simply as a function of their freedom to contract with the tenant to alter terms of the lease. It means that the landlords don't get dragged into litigation about whether or not they've reasonably withheld consent. They know that they retain the absolute control that comes with the ability to decide whether or not to agree a variation of the covenant. And the second thing that conveyancing solicitors know is that in practice, landlords routinely grant licences to carry out works falling within covenants like clause 2.7. And we see that also reflected in the statutory background. It's the same volume of authorities, volume 1, tab 12. It's page 568 of the bundle, and it's section 143 of the Law of Property Act 1925, to which Lord Justice Lewison did make reference in his statement. And section 143 makes clear what probably is not very controversial in the modern law, but might perhaps have been more controversial in centuries past, that where a licence is granted to a lessee to do any act, the licence, unless otherwise expressed, extends only to the permission actually given, or to the specific breach of any provision or covenant referred to, or to any other matter thereby specifically authorised to be done, and the licence does not prevent any proceeding for any subsequent breach unless otherwise specified in the licence. And subsection 2 makes clear that notwithstanding any such licence, all rights under covenants and powers of re-entry contained in the lease remain in full force and are available as against any subsequent breach of covenant, condition or other matter not specifically authorised or waived, in the same matter as if no licence had been granted. And the conditional right of entry remains in force in all respects as if the licence had not been granted, save in respect of the particular matter authorised to be done. That provision makes clear that if a landlord grants a licence to Mrs. Winfield to carry out a particular scheme of works, that doesn't mean that it authorises any other scheme of works, and it doesn't mean that clause 2.7 or 2.6 are invalidated for the future, that they remain effective.
Can you help us to the contractual analysis when the licence is granted? Does it, just in relation to that item, vary the original lease terms?
It will depend on the form and the content of the permission given. So, as a matter of law, it seems to us that a permission to carry out works, for example, could be one of a number of things. Sorry, I've just got some notes on this. It could be a variation of the lease if it's granted formally by deed and its effect is to permit something that would otherwise not be permitted by the lease. It could be a collateral contract, for example, if it's not effected in a sufficiently formal way. It could be seen as the waiver of a term which is for the sole benefit of the landlord. So if you have a contractual term which is for one party's sole benefit, they are able to waive that. It could be a form of estoppel, so it could be a representation, particularly if made orally, a representation to the tenant that it is permitted to carry out these works from which the landlord cannot then resile in equity. And there are also issues about there could be an election between remedies. For example, a landlord might waive the right to forfeit a lease but continue to retain a right for damages. So as between the, and indeed one should reflect on the fact that such an agreement might be made before any activity takes place, or it might be made after any activity takes place.
You know, of course, why I'm asking, because of 3.19.
Yes, exactly.
Because it could fall foul of that, couldn't it?
It could, and that's essentially what the Court of Appeal decided. And I'll obviously elaborate in due course when we look at clause 3.19, but our submission is that what was anticipated here was in effect a variation to Mrs. Winfield's lease, but just for the purpose of carrying out the particular scheme of works that she wanted to carry out. So it wouldn't otherwise deprive clause 2.7 of its effect and meaning. It was proposed to be granted by a formal licence, and it was proposed to be granted before any works had taken place. And so we say there was never a breach here, there was never a threatened breach here. This was something that was going to be authorised before it was carried out, and not carried out if it wasn't authorised, in which case there would never be a breach. Just to...
Sorry, just
yes.
but on this interpretation of 2.7, it doesn't demand a previous written consent. It could be a licence granted before or after the work, orally or in writing.
So, absolutely, my lord, that's right. So, as between the landlord giving permission and the tenant who has the permission, it doesn't really matter whether you characterise something as a variation of the lease or giving rise to an estoppel or a waiver. More complicated question comes when you want to say what is the effect of that agreement as between a successor in title to either the landlord or the tenant, because you're dealing with a covenant that will run with the term and with the reversion. And that gives rise to a whole host of quite complex problems associated with the fact that whether or not an agreement may be relied upon by successors may depend in part on issues of land registration and the priorities rules associated with land registration. It's complicated by the fact that we've had a change in the statutory framework for the running of landlords and tenants covenants. So the Landlord and Tenant Covenants Act 1995 changed and liberated the way in which covenants run to successors and included collateral agreements which weren't variations, whereas the leases we're dealing with here predate that act. And it's also complicated by the fact that there are a couple of Court of Appeal authorities which suggest it all doesn't really matter and that you can vary a lease orally or without a deed, but which haven't been scrutinised by this court and might perhaps not survive that scrutiny. So, as between my client, the landlord, and Mrs. Winfield, it doesn't really matter whether the licence was proposed to be by deed, in writing but not by deed, or orally. Any one of those situations would have given Mrs. Winfield a complete defence if the landlord had subsequently sought to sue Mrs Winfield for carrying out works in breach of clause 2.7. But those different forms and different content may potentially have had an impact if you were looking at a different question, namely if Mrs Winfield sold her flat to somebody else or the landlord sold its reversion to somebody else, would that agreement still be binding?
I think I should make clear, given your answer, that the Court of Appeal dealt with 3.19, and of course they did, but there's two halves to 3.19, yes. And it was the first part of 3.19 I was thinking of, and the second half that they were thinking of.
Well, there are obvious that the Court of Appeal do deal with the first part of clause 3.19, and there's also obviously some implicit assumptions about the effect of the first part of clause 3.19 that we say are wrong and that we would like to tease out.
Well, don't take it out of turn. But...
No, thank you very much, my lady. So we were just looking at section 143 of the Law of Property Act, electronic bundle, page 568. And what I'd just ask your ladyships, your lordships to note is subsection 4, which says that this section applies to licences granted after the 13th day of August 1859. And that reflects the fact that this section is a reenactment of earlier legislation. It's a reenactment of the Law of Property Amendment Act 1859. And I mention that merely for the purpose of showing that the concept of licences granted to lessees is something which has a really well-established history in landlord and tenant law, and it's seen as absolutely commonplace. And it's also of interest that the lease chooses to use the word licence. We looked at clause 2.14.2, which uses licence or consent, and echoing the language which is used in section 143 when referring to a licence, which clearly is intended to give the lessee permission to do what would otherwise be a breach of their lease. So what we say is that the parties to Dr. Duval's lease, Dr. Duval on the one hand and the Church Commissioners in 1986, they objectively know that she or her successors are going to have to rely on licences granted by the landlord to depart from the covenants, like clause 2.7, if her flat is to be modernised and be a capital asset with value and a home over the full course of the 125 years of the term. And they also know that the same applies to Dr. Duval's neighbours, like Mrs. Winfield. In order for these leases to be workable documents that are going to last for a century and a quarter, in respect of properties where a bathroom only lasts 20 years at most, a kitchen 20 years at most, the neighbours are also going to have to rely upon licences.
Sorry, mine all lasted much longer.
40 years at most, perhaps, my lady. So the question, one of the questions is, how far has the landlord contracted away its ability to enable people like Mrs. Winfield to carry out the works that they will need to carry out on their flats to keep them up to date over time? And does the person in Dr. Duval's position who's objecting to the works want a lease where their own lease is so narrowly confined that no licences can be granted? Because that is also, Dr. Duval may be wanting to object to Mrs. Winfield's works now, here in 2019, but perhaps in 20 years' time, a successor of hers will be the one who wants to carry out the works. And does she want to have a lease which dictates that her neighbours have a say over whether or not she can carry out her own modernisation works?
One might say it's generally in the interest of the neighbours that the property should be kept up to date and maintain its value in the block.
On the other hand, one might think that it protects the capital value of their properties, that if they can object to unreasonable or potentially damaging works by a neighbour.
Yes, my lord, and what I'll come on to show you is that there are a whole host of existing protections which we say would enable a person to be protected from unreasonable works, and that it's not necessary to take the next step that the Court of Appeal did and imply a term over and above those existing protections. May I come back to that?
Definitely.
I indicated that I wanted to deal with an argument that the respondent puts forward, which is this, that it's suggested that the court should place little or no weight on those sorts of factors and the ones that we have mentioned in our written case, because these are registered leases and therefore public documents. We accept the principle that the nature of a particular document which is being interpreted may affect the weight which is given to context rather than to the words used in it. And this court has discussed that principle in various contexts, such as in relation to planning consents and pension deeds. But the respondent's argument is anachronistic because the appropriate interpretive tools must be chosen, must be judged against the context in which the parties made their agreement. And when these leases were granted in the 1980s, the register was not open. Only the registered proprietor and very limited classes of other people could see the register or obtain copies of documents. And my Lady Hale may recall being on the Law Commission in the mid-1980s, which recommended the opening up of the register, and that happened with effect from 1990, December 1990. So it was only after that date that the register became public. And even nowadays, although we do have a public register and the leases are available to be inspected by all, that's not the case. It's not the case that by looking at the register you can be sure that you will see all licences or variations to leases. And that's because only deeds of variation which affect a disposition are subject to compulsory registration. So if a deed of variation affects a surrender and regrant of a lease, then it needs to be registered to be effective in law. But most licences, including licences to carry out a particular scheme of works, won't actually affect a disposition. Some of them might get onto the registered title voluntarily, as it were, but a person looking at the register can't be sure that what they're seeing is complete and accurately shows an up-to-date position for all of the covenants in the leases. That's something that indeed the Law Commission consulted on in 2016. But if we look back to the 1980s when these leases were granted, the parties to the leases would have understood that if a tenant wanted to understand what the state of the covenants were under which a neighbour occupied, they could only do so effectively by asking their landlord for a copy of the lease and of any licences granted under it. In any event, we say this principle is about choosing what are the appropriate tools with which to tackle an interpretation question. It's not about, for example, favouring a literal over a purposive interpretation. And that point was made in this court. If I can ask your lordships to turn up, please, the second volume of the Authorities Bundle, tab 2, page 587. This is the decision in Barnardo's in Buckinghamshire. And essentially, Barnardo's, as an employer, wished to replace references to the RPI index in a pension deed with references to the CPI index. And the question arose whether it could under the terms of the pension deed. And there was a discussion about the weight to be applied to contextual factors. If I could ask you please to go to bundle page 593, that's page 181 of the report. Could I ask you please to read from just above little letter C in deciding which interpretive tools, down to letter G, please? And then over the page 594, if I could ask you please to read paragraph 16. So the point that Lord Hudge makes in paragraph 16 is that even in the case of a document like a pension deed, where it's appropriate to place more weight on the text rather than the context, that doesn't mean that you take a literal rather than a purposive approach. What we say is that the kind of contextual features that we're relying upon are not information which is only known to the parties. We're not relying upon a side letter of some sort or a document that would not be known. We're simply relying on features of the lease itself, for example, the length of its term, and information that would be known to the general public by way of landlord and tenant law or landlord and tenant practice. We say they're all things which properly feed into a proper understanding of the leases and the background against which they fall to be interpreted. So I now turn to the second part of my submissions, which is the construction of the express terms of clause 3.19. We deal with this in our written case at paragraphs 30 to 39. It starts on page 85 of the bundle. If I could ask you please to turn up clause 3.19. It's at page 204 of the bundle, core bundle, tab 8, little 7. And as my Lady Black observes, there are two parts of clause 319. And
Yes, in our own lease, they're in two different clauses.
interesting.
Which is interesting.
Yes. One would need to read them together, I suppose, anyway. It probably doesn't make any difference whether they're two separate clauses or all in one. So we say that the first part of clause 3.19 received insufficient attention from the Court of Appeal. It provides that every lease of a residential unit in the building hereafter granted by the landlord at a premium, so it relates to specific kinds of leases and not every lease, shall contain regulations to be observed by the tenant thereof in similar terms to those contained in the 5th schedule hereto, and also covenants of a similar nature to those contained in clauses 2 and 3 of this lease. Clause 2 is the tenant's covenants, clause 3 are the landlord's covenants. And the Court of Appeal concentrated on the word covenant in the phrase covenants of a similar nature to those contained in clauses 2 and 3 of this lease, making the point that this means effective legal obligations. We don't disagree with that proposition. And it's not simply about words on a page, it is about an effective legal obligation. But what the Court of Appeal did not interrogate were the words which followed, covenants of a similar nature. And that phrase appears twice in clause 3.19, here in the first part, and then again towards the end of the second part. where the covenant is to enforce any covenants, etc., of a similar nature to those contained in Clause 2 of this lease. In relation to the first part of Clause 3.19, there are two relevant questions which Lord Justice Lewison's judgment, we say, elides. The first is, those leases which fall within 3.19, that is to say, a lease of a residential unit hereafter granted by the landlord at a premium, when they are granted, are they to be on identical terms to this lease? So that's about the degree of correlation between this lease and another lease in the building. The second question is, has the landlord covenanted by Clause 3.19 not to vary the covenants in that other lease at any time thereafter? You see both of those concepts rather run together in the judgment of the Court of Appeal. So teasing out those two separate questions and addressing the first, are the other leases to be on identical terms to this lease? What we see that the clause requires first is that the other leases are to contain regulations to be observed by the tenant in similar terms to those contained in the fifth schedule here too. But what we know is that under clause 2.20, the regulations in the fifth schedule can be unilaterally amended by the landlord. So presumably what the parties intended was that if there was a relevant lease granted, say, 20 years after this lease was granted, that it would contain the regulations in their amended form that were then governing all of the leases in the building, not in the original form in which they appear in the fifth schedule. So it appears from that, we would say, that the word similar doesn't mean identical. It must allow for some updating. And then we see, secondly, that the lease must contain covenants of a similar nature to those contained in clauses 2 and 3 of this lease. So the requirement is not that the covenants should be in similar terms, which is the language used in respect to the regulations. It is that they are to be covenants of a similar nature. We say that means that, for example, a lease should contain a repairing covenant. It should contain an alterations covenant. It should contain a covenant against waste. But in answer to the first question, the first part of clause 3.19 does not require other relevant leases to be on the same terms as this lease, as long as they are of a similar nature. And as to the second question, can the landlord subsequently vary those covenants? We accept that this part of clause 3.19 imposes a continuing obligation on the landlord. It is that every lease shall contain the regulations and covenants. It wouldn't be open to a landlord to grant a lease and then completely change all of the covenants in it and say, I complied with my obligation because at the moment I granted the other lease, it contained covenants of a similar nature. The landlord covenants that every lease will continue to contain covenants of a similar nature. But the obligation is only that the leases shall contain covenants of a similar nature. In our submission, it doesn't mean that the landlord has given up its freedom to enter into consensual variations with other tenants, except to the extent that those variations meant that the leases no longer contained covenants of a similar nature. So, a landlord, we say, having granted a lease to Mrs. Winfield, which contains clause 2.7, can vary that lease by agreement with Mrs. Winfield so as to permit a particular scheme of works. Mrs. Winfield's lease will still contain covenants of a similar nature to those contained in clauses 2 and 3 of this lease. These leases need to be workable documents which will survive for a very long period of time. The parties we would submit are unlikely to have intended that each tenant's lease should be completely ossified for a century and a quarter. And we say the words used in the first part of clause 3.19 do not dictate that outcome. They do not say that every lease will contain identical covenants. They do not imply or express that the landlord can't exercise its ability, its freedom to enter into variations subject to the constraint that the covenants must remain covenants of a similar nature to those contained in this lease. And then we turn to the second part of clause 3.19. At the request of the tenant and subject to payment by the tenant of and provision beforehand of security for the costs of the landlord on a complete indemnity basis, to enforce any covenants entered into with the landlord by a tenant of any residential unit in the building of a similar nature to those contained in clause 2 of this lease, clause 2 being the tenant's covenants. So we note again that it is only in relation to covenants of a similar nature to clause 2 that this tenant is allowed to request enforcement. If that mirrors the first part of clause 3.19. If you do what the Court of Appeal implicitly did and read covenants of a similar nature to mean covenants in identical terms, that cuts down the ability of a tenant like Dr. Duval to rely on the second part of clause 3.19. If there was only a minor variation between the terms of this lease and the lease which is to be enforced, then that would prevent the tenant having the right to enforce the covenants. We submit that the meaning of the two parts of clause 3.19 is that the landlord is within the first part if it permits a variation, as long as that covenant doesn't cease to be a covenant of a similar nature, and then the tenant is entitled to request enforcement of that covenant of a similar nature. So that means that the landlord is permitted to vary Mrs. Winfield's lease to the extent of allowing a particular scheme of works, which would otherwise be prohibited by clause 2.7, as long as it doesn't remove clause 2.7 altogether or render it so different that it's no longer a covenant of a similar nature.
So that's the break in your submission, is it, on what the landlord can do? It's the limit to what the landlord can do under 2.7.
We say that's a constraint on the landlord.
Yeah.
But if I'm the tenant entering into this lease, I'm going to say, well, what's going to govern the landlord's decision on whether to license me to do this, that, or the other? It's not not to be unreasonably withheld position, and I might also be worrying about what he's going to say to the other tenants when they seek it, that he might be over-generous, so he could be erring either way. What is the provision that governs that?
So there are, we'll look at them in a little bit more detail later, but there are a whole host of constraints on the landlord's ability to grant Mrs. Winfield a licence which impacts on Dr. Duval. And it's partly a consequence of the express terms of this agreement. So the first part of 3.19 is a constraint on the landlord. Covenants must remain of a similar nature. The express provisions for quiet enjoyment are a constraint on the landlord. Repairing obligations are also a constraint on the landlord because the landlord has repairing obligations. Also, importantly, landlords are subject to the implied obligation not to derogate from their grant, which, as it were, infuses the lease and colours the construction of the obligations in it. And that prevents the landlord granting a licence to Mrs. Winfield in this case in such a way as to derogate from the ability of Dr. Duval to use her flat as a residential flat and also to enjoy the express easements that she's been given to use the common parts.
If I'm Mrs. Winfield, I might be worrying the opposite way, that he's not going to grant me the licence.
Yes.
And how do I challenge that?
You can't. You can't challenge it because it's an absolute covenant.
Yes.
But as I've submitted to your ladyships and your lordships already, in practice landlords do.
But I'm entering into this. There's no way in which I can challenge him. And yet the defect of the absolute covenant you've already laid before us in graphic detail.
As I said, it is... There are 2 points. One is the one that I've already made, which is that it makes no sense for these tenants to have entered into leases in these terms, but thousands and thousands and thousands of tenants do. The reason they do, the reason they're allowed to do by their advisors and by their lenders, is because in practice landlords do grant licences. Now it's true, as my lady observes, that all of the tenants will want to carry out some work falling within clause point 2.7 in the course of their 125-year term. And they take the legal risk that the landlord might say no. That risk, however, is ameliorated in a circumstance like this one, where you also acquire a share in the landlord company. And so that's a different form of control and protection against arbitrary behaviour. And it's one of the reasons why share of freehold schemes are encouraged. They're encouraged by legislation, for example, to enfranchisement, that having the ability to have a say in how the landlord takes its decisions about whether or not to grant consent is done by virtue of your ownership in the company, rather than by virtue of the lease terms.
There are many leases where that's not the case.
There are. So just turning back to the second part of clause 3.19, what I'll ask your lordships and ladyships next to note is the formality of the conditions precedent to action by the landlord under this provision. The tenant not only has to make a request, it's not only liable to indemnify the landlord on a complete indemnity basis for its costs of enforcement action, but it's required to make provision beforehand of security for those costs. Clearly, that's important for the landlord, which has no income, and for protecting the other tenants in the building who will otherwise have to meet the costs of enforcement action through their service charges. So it's important that if the complaining tenant is going to require a landlord to take action, that it puts its money where its mouth is, or he or she puts their money where their mouth is. Those condition precedent are important because in our submission they signal to the objecting tenant that this is a really serious business. And if you're going to require your landlord to take action against one of your neighbours, you're going to have to cough up a lot of money for this. You're going to have to put forward security beforehand. And that is an important break on unreasonable behaviour, say. tenants likely to think very carefully before asking a landlord to enter into a dispute with their neighbour. And then what does it mean to enforce any covenants? We say here, in context, it means taking action in reliance on the landlord's legal rights in response to a breach or threatened breach. We submit that that construction reflects the natural use of language in its context, and it's needed to make sense of these preconditions. A request indicates that there's something to complain about. The suggestion that there will be costs of the landlord to be met on a complete indemnity basis and for which security needs to be provided beforehand indicates that we're dealing with legal costs of enforcement action. It can't mean the landlord's costs of dealing with an application for a licence by the person in Mrs. Winfield's position, because we know from clause 2.14.2 that Mrs. Winfield is liable for those costs. The costs which are being discussed here can only mean the legal costs of taking enforcement action in respect of a breach or threatened breach. So we accept that where there is a breach or threatened breach of covenant by one tenant, and another tenant makes a request, provides security, and it's also required to pay its service charges. That's right at the beginning of the tenant's covenants. Sorry, that is page 199, I'm told. Thank you. Sorry, right at the beginning of the landlord's covenants, yes. Clause 3 starts, subject to the payment by the tenant of the service charge. Internal pagination 22. But where the tenant has made the request, has paid its service charge, and has provided the security beforehand, then the landlord must take appropriate action. It can't then licence the breach.
Why not?
Because that would be to fail to take the enforcement action.
But if the landlord were to decide on reflection that it's a change that could reasonably be made, why could the landlord not license at that stage and do so retrospectively?
Well, because we would suggest it has promised Dr. Duval that it will enforce any covenants.
So, insofar as there's a license, there wouldn't be a breach of the covenant on your submission.
No, that's right. But sorry. So, if a license has been granted before any activity is taken out, there is never a breach. So the second part of clause 3.19 is not engaged at all.
I understand.
If there is a breach, we say it is open to the landlord to license that breach, because there is no implied term, we'll come on to that, but there's no implication that it can't license that breach. But once the request has been made, if there is a breach or a threatened breach, once the request has been made, the security has been given, the service charges is paid, then the landlord is under an obligation to enforce the covenants in the other party's lease.
The covenants as they were at the time when the request was made.
At the covenants as they were at the time the request was made, because it would effectively, it would denude this part of clause 3.19 of any effect if the landlord had a completely free hand after essentially the objecting tenant has taken on the costs risk of enforcement. It would then be for a matter for agreement. So if the objecting tenant who's provided the security for costs is happy for some retrospective validation, retrospective licence to be granted, then that no doubt can be done. But we would accept that the landlord is obliged to enforce against the breach of covenant which has taken place at the time of the request, if the tenant has provided the security.
I'm not quite sure what the logic of the position where on your submission the landlord would have freedom if everything had been done properly beforehand and they granted a variation of the covenants, and then the second tenant doesn't get the protection of 3.19. But something's gone amiss, that the landlord didn't see the correspondence, but then sees that actually this is a variation which looks acceptable to the landlord. Why the landlord should not have freedom at that point to grant a variation at that stage.
It's simply the question of whether there's an express term or there's an implied term. So until the request and payment of security has been made, there is no obligation at all on the landlord under the express terms of clause 3.19. Once there has been a request and the security for costs has been given, then there is some obligation on the landlord. The question is, what is that obligation? And that's a question of construing the second part of clause 3.19. Now, it may be that your ladyships, your lordships disagree with our position and don't consider that the second part of 3.19 prohibits a landlord granting licence after those preconditions have been satisfied, but that's a question of construing the words which have been used. This is an express term. The position which applies before the tenant has made a request and provided security is not governed by the express terms of this lease. That can only be governed, if at all, by an implied term. That's why there is a difference, or at least a potential difference, between the handling of the position before a request is made and security is provided and after a request is made and security is provided.
Sorry, just to press you on this. Why isn't the obligation to enforce qualified by the covenants being of a similar nature?
It is covenant.
So why wouldn't, on your argument, the landlord have freedom after the changes have been made, but the landlord thinks that they're reasonable changes, then to vary the lease? And the varied lease still contains covenants of a similar nature, because your argument is that it can be varied beforehand with covenants of a similar nature.
Yes, it depends whether one reads this part of clause 3.19 as freezing the position at the date of the request of the tenant, essentially. And if one takes a step back and looks at the sort of commercial purpose of this part, the tenant is required to take a big step. It's required to put up security for the costs of legal action to be taken by the landlord. It might feel he or she might feel quite upset that the landlord then takes unilateral action. Because
but when they get the money back, I mean, if the landlord doesn't pursue legal action for which the security has been given, doesn't the landlord pay back the money then?
yes, if the landlord didn't, but
Surely your point is simply that once the request is made, supported by the appropriate security, then it's clear on the clause that the landlord has to do something.
yes,
Obviously,
yes.
there are questions about what the nature of that obligation is.
Yes.
We're not in that position. We're in a position where we haven't got to that.
Exactly, my lord.
It's purely a matter of implication
Yes,
of whether he has to do anything at all. And
yes,
so in a sense where, whatever the answer is to my lord's question, it's not the question which we're faced with.
That's absolutely right, and we're not faced with that on the agreed facts of this case, because the second part of clause 3.19 was never engaged at all, for two reasons. Firstly, Mrs. Winfield did not breach or threaten to breach her lease. She simply applied for a licence, and had the licence been granted, then she would have carried out the works in accordance with that licence and not in breach of her lease. So all she was doing something which is expressly contemplated by her own lease, namely applying for a licence to the landlord. So we say that the circumstances to which the second part of clause 3.19 appertain never arose.
But suppose the breach is there already,
Yes.
and no request has yet been made,
Yes.
but the landlord decides retrospectively to licence the breach. Then what's the position?
The relevant legal question then is there an implied term which prevents the landlord licensing that breach? And we say there is no such implied term, because it is not necessary for business efficacy or obvious that such a term should be implied.
Why is the landlord not in a situation of anticipatory breach?
So, an anticipatory breach is a name given to a circumstance which allows one party to treat a contract as being at an end and having been terminated for the repudiation of the other party. But it is not a real breach. An anticipatory breach is contrasted with an actual breach of contract. It's a fiction developed in the Victorian period. So, a landlord, there are two forms of anticipatory breach, and one of them is self-induced impossibility, making it impossible for you to comply with your obligations when they arise in the future, at a time before performance of those obligations is
So
called
I
for.
agree to charter my ship to you, and then I scuttle it before the date the charter begins.
Yes. So, sorry, my lady, excuse me.
But here the landlord agrees to enforce breaches
Yes.
and then puts it out of his power to do so before he does it.
So, my lady, this case has never been concerned with the question, can Dr. Duval put an end to her lease because the landlord has repudiated it? And in fact,
I'm not suggesting that it's
No.
precisely like that.
No. So, but that's important, because that is all the doctrine of anticipatory breach is concerned with. All it means is that where one party to a contract makes it impossible for themselves to perform their obligations in advance of the time for performance, the other party may accept that repudiation and treat the contract as being at an end. But it's just a legal fiction of breach. It doesn't have any legal consequences unless and until it's accepted by the innocent party as bringing the contract to an end. And the phrase is that it's a thing writ in water. It doesn't give rise to any legal consequences in terms of damages or an injunction. So, in fact, and I'll perhaps develop this a little bit later, but once it's recognised...
Just on the injunction,
Sorry.
you could get a queer TMET injunction, couldn't you, if there's a threat?
If it's a threatened breach, but that would be to recognise a future actual breach as opposed to an anticipatory breach happening today. So, perhaps you can use some analogies. If I use the analogies of the marriage cases, I know it's a bit old-fashioned, but they might be helpful. Let's say that I promised to marry Mr. Smith on the 10th of October. I breach that express promise if I don't marry Mr. Smith on the 10th of October. It doesn't matter for that purpose whether the reason I haven't married Mr. Smith on the 10th of October is because I've made it impossible for myself to marry him because I've married somebody else on the 10th of September, or because I'm too busy in the Supreme Court, or I've forgotten it's my wedding day. It's the not marrying, which is the breach at the time when performance is called for. So the question is, do any legal consequences attach to me on the 10th of September when I marry Mr. Jones instead? Now, one answer could be, on the 10th of September, I commit an anticipatory breach. But that only has legal consequences if it is accepted on the 10th, following the 10th of September, and is accepted as bringing an end to the contract under which I've agreed to marry Mr. Smith. If legal consequences are to otherwise attach to my marrying Mr. Jones on the 10th of September, it has to be because there is an actual breach.
But I'm sorry to press you on the queer timid injunction. If it's discovered that you're about to marry Mr. Smith on the 10th of September, couldn't the person to whom you've made the promise to marry them a month later get a queer timid injunction to stop you marrying Mr. Smith?
Yes, but that would not be because I have committed a breach on the 10th of September. It would be because I will not be marrying Mr. Smith on the 10th of October. So it's looking to the future for performance of my obligation to marry Mr. Smith on the 10th of October.
Unfortunately, these marriage analogies are all complicated by various public policy considerations, that make them not very helpful when dealing with a rather more commercial situation.
Yes.
One never had specific performance of contracts to marry.
Well, they're no longer enforceable.
They're no longer enforceable since 1970.
I'm sorry, just coming back to Mrs. Winfield then. Supposing she'd carried out this work in secret,
Yes.
and the landlord had then found out about it,
Yes.
and Dr. Duval had found out about it.
Yes.
Could the landlord at that point license the work?
If Dr. Duval had found out about it but not made a request and not provided the security, yes.
Right.
Because the express provisions of clause 3.19 don't apply.
Yes, I understand. Thank you.
I mean, the strength of your position, right or wrong, is that you're simply looking at the words of the clause and say, well, when does an obligation arise?
Yes.
It arise on certain conditions.
Yes.
And you're not really speculating about what might happen in other situations. You're just saying, let's stick with the words of the clause.
That's right.
What they did in Arnold and Britain, to my displeasure.
Sorry. I just wanted to ask, in your reply to Lord Kitchen's question, you seem to build in some notion of reasonable notice to Dr. Duval, in the light of which she doesn't take action to request, then
Didn't intend to, my lord. If that was implied, I didn't intend to. Our position is, and I think my Lord Carnwath has captured it, there is an express obligation in clause 3.19 to take enforcement action, we say, after a breach or threatened breach, and in circumstances where the tenant has fulfilled the conditions of that clause 3.19. Up until the tenant fulfills those conditions, the landlord has a free hand. It's under no obligation to tell Dr. Duval about it. It's under no obligation to ask anybody else about it. It has the power to make a judgment whether or not it's appropriate for that activity to be licensed after it has taken place.
Well, suppose Dr. Duval, after 2 years, says, here's the security, now in force. What happens then, where the licence has only been granted after Ms. Winfield has carried out the works, unbeknownst to the landlord originally, but then discovered?
We say it's necessarily inherent in clause 3.19 that there is still something to enforce. So if by the time the security is given and the request is made, a licence has already been granted, whether that's before or after the breach, the landlord has no effective right of action against Mrs. Winfield in that circumstance. So there is no point to the tenant, the objecting tenant, Dr. Duval, providing security for the costs of enforcement action, because the landlord no longer has an effective right of action against the person who has committed the breach, because they've dealt with it by licence.
It can be said that that makes the protection for Dr. Duval very precarious.
My lord, I would suggest no, and it's for a number of reasons. One is that there are sufficient existing protections that the only circumstance in which this is likely to be an issue is one where Dr. Duval is not personally impacted in her occupation of her flat or her use of the common parts by the activity which is sought to be licensed. I'll deal with that a little bit later in our case. Sorry, I've lost my thread of thought. I do apologise.
I imagine your submission is that if Dr. Duval is impacted, then then this would be a licence that would be precluded because of the
Yes.
other covenants in the lease.
Yes, that was the first point. I think I had a second point to make, but I'm afraid I've just momentarily lost that, for which I apologise to my Lord Sales. Yes. Ms. Murphy makes the valid point that you are, as a tenant like Dr. Duval, most likely to find out about things that actually affect your flat.
Right, but you might find out after a period of time.
You might.
You know, the blocked rubbish chute or something like that. It's only then that you realise, oh, things have been happening.
Yes.
Which, if I'd known in time, I'd have had, as I understand it, on your argument, an opportunity to foreclose by giving the landlord the security and saying, please enforce. But that's all been lost just because things happen surreptitiously.
Well, but one has to balance that against the alternative, which effectively requires the landlord positively to gain the consent of all of the tenants in the block before it can do anything. Because if it's right that the landlord doesn't, if the landlord has contracted away its freedom to enter into a licence with Mrs. Winfield, it can only enter into that licence if it can get every other tenant in the block positively to consent to waiving their rights under clause 3.19 or under the implied term, which has the opposite effect that if a tenant is away, abroad, it's not possible, it's not feasible to get a positive consent from that tenant, with the consequence that Mrs. Winfield can never carry out the works that she needs to be able to carry out, and which the landlord is happy to license her to carry out in order to modernise her flat. So,
In fact, that was one reason why I was interested in what I now understand was my misunderstanding of your answer to Lord Kitchen, whether there might be inherent in 3.19 some idea of the landlord giving notice or the other tenant giving notice of things happening, and a tenant wishing to rely upon their rights under 3.19, then having, I don't know, a reasonable period of time in which to take action, and if they don't, things can proceed. But you say it doesn't work.
well, there is nothing expressed in the leases which provides any kind of framework for the giving of notice to tenants. So one would have to be implying a very broad term about giving reasonable notice to other tenants to allow them to come forward, which
I can see that.
would be workable. And so obviously the tenant who may object has its rights as a shareholder in the landlord company, and it will get some information in that way. If she or he is affected by what goes on, they are likely to know about it. there is a category of case where a tenant simply doesn't know about something that it could perhaps have complained about, but if you try to address that position, you end up completely skewing the balance of these leases in the building, because you end up effectively hamstringing the landlord until it's positively had consent from all of the tenants in the building, which is very impractical.
Thank you.
So I'm conscious of time.
Yes, well, you had indented for 2 hours. You've now had your 2 hours.
I have,
But
indeed.
as I understand it, if you go on longer than your 2 hours, that'll come off your very generous time in reply. Is that correct?
That's correct, my
So
lady.
how much longer do you think you're going to be?
My lady, so if I take another half an hour
Until the short adjournment, then?
until the short adjournment, and then if that comes off.
Yes. Just means she's got less time to come back at you, Mr.
I don't
Moore.
think this causes me any embarrassment, my lady.
No.
My lords and ladies, I was now proposing to turn to the third part of my submissions, which is the question, are we dealing with an implied term or are we dealing with a rule of law? And also to address the respondent's alternative analysis. So the Court of Appeal, this is our written case, paragraphs 41 to 46, starting at page 90. The Court of Appeal posed the question, if a landlord grants a licence permitting what would otherwise be a breach of an absolute covenant, does he commit a breach of clause 3.19? And accepted that clause 3.19 doesn't say that. And so that the question is whether it's necessarily implicit, and that requires the application of the well-known business efficacy and obviousness tests recently restated in Marks and Spencer's case. But Lord Justice Lewison also gives a nod to the fact that Lord Atkin, in the Southern Foundries and Sherlaw case, characterises this as a rule of law, and although he says the taxonomy doesn't make a difference. And that approach is consistent with the way in which Lord Justice Lewison puts it in his textbook on interpretation of contracts, where it's said to be possible that these terms around prevention of performance rest on a rule of law rather than an implied term, but the implied term analysis is preferred, and Chitty just deals with them as implied terms, as it were. Both Lewison and Chitty, Lewison on interpretation of contracts and Chitty, treat all of these performance-related obligations under the same head, all as a form of implied term. We say they're right to do so. So questions which arise about whether a party owes an obligation not to disable itself from performing its own obligations rest on the same analytical foundations as whether a party owes an obligation not to disable the other party from performing their obligations, or whether the parties must cooperate. And the respondent offers a rather different analysis. They have two arguments. It's suggested firstly that there is neither an implied term nor a rule of law, because by undertaking to enforce the covenants of the lease, the landlord has automatically undertaken not to do the opposite, namely licence breaches of covenant. And secondly, it's said that there is a term which is imposed into the lease. And we submit that the logic in that respect is badly flawed and ignores some fundamental principles of contract law. So there is no breach of an express term until the time for performance of that obligation has arisen. And where the obligation is contingent or conditional, time for performance does not arise until that contingency has been satisfied or the conditions have been satisfied. But once there is a breach of an express term, there's no need to have recourse to the concept of self-imposed impossibility to explain that breach. So, as I've said, if I fail to marry Mr. Smith on the 10th of October, it doesn't matter whether that's because I've married Mr. Jones on the 10th of September or not. The opposite of marrying Mr. Smith on the 10th of October is not marrying somebody else, it's not marrying Mr. Smith. So the concept of self-imposed impossibility, or putting it out of one's power, is only relevant if legal consequences are to attach to action or inaction before the time of the performance of the express obligation has arisen. So, am I capable of being sued for damages or being the subject of an injunction on the 10th of September when I marry Mr. Jones? And that can only be because a term is to be implied into the contract that I am not to marry another person, or because there's some other rule of contract law. If the Court of Appeal is right, that the landlord is in breach of its obligations to Dr. Duval in advance of Dr. Duval complying with the conditions attaching to clause 3.19, then it can't be in breach of the express provisions of clause 3.19. And it's very well established that there are two types of implied terms: standardised terms imposed by statute or common law into particular contractual relationships, often traditionally called terms implied in law, or terms implied into a particular contract to reflect the intention of the parties, which need to satisfy the business efficacy or obviousness tests. And the kind of implied terms that we are dealing with, which relate to performance, are firmly established in high authority as being of the second kind, that is to say, implied into a particular contract only if it's necessary to give business efficacy and or it be obvious to do so. And we've set out the authority in our written case. It's paragraphs 43 to 46, pages 90 to 93. We deal there with all of the cases that the Court of Appeal cites. We've set out a number of authorities, including recent authority, indeed, of my Lord Sales in the Lord of Benchland Ukraine case, and of Lord Carnworth in the Privy Council in the Allian Petroleum Company of Trinidad and Tobago case, which clearly locate these obligations in the law of implied terms and required to satisfy the Marks and Spencer's tests. And there's been no answer to those submissions in the respondent's written case, so we really are in the dark as to what they say about those cases. For that reason, I'll come back in reply if the respondent is going to interrogate or challenge the authority that we rely on. And there is a single lone voice of Lord Atkin in the Southern Foundries and Sherlaw case. That is in the Authorities, Volume 1, tab 9, and it's at page 529 of the bundle, page 717 of the report. And if I could ask the Court please to read from the top of page 717 down to the middle, where it says not to marry anyone else, but for breach of his contract to marry B.
So what's the MS number, 717?
It's internal pagination 717, bundle page 529, my lord.
Personally, he says, personally.
Personally, indeed. And that reasoning doesn't reflect any other of the speeches in this case. Three of their lordships clearly treat the Stirling and Maitland principle as a proposition about an implied term. Lord Wright is more difficult to make out, I have to say. He seems to be dealing with matters on the basis of an express term. But Lord Atkin is the only one in this authority who says it should be a rule of law. It's not consistent with authority, including at House of Lords level before Sherlaw. It's not consistent with authority, including at Privy Council and House of Lords and Court of Appeal level after Sherlaw. It's not consistent with the other speeches in Share Law itself, and in our submission it's not right. The example he gives of the marriage contract doesn't distinguish between a case where the obligation to marry B has arisen, in which case, as I've submitted to you, the rule of law is superfluous, or where it has not, in which case it is out of line with principle indicating that we're looking for an implied term. So, my ladies and my lords, we say it is clear that the relevant question is there a term to be implied into Dr. Duval's lease that the landlord must refuse Mrs. Winfield's request for a licence for works unless all the other tenants in the building are prepared to waive their rights to enforce. Just by way of clarity, I should explain that there are two reasons why Dr. Duval didn't satisfy the conditions precedent to the second part of clause 3.19. The first was, as I've mentioned, that Mrs. Winfield was not in breach or threatened breach of her lease. And the second is that Dr. Duval didn't provide security for the landlord's costs. And hearing that it's not agreed, and the respondent asserts in their written case that security was offered, but you will find no reference to it in the agreed statement of facts and issues. And we say it has absolutely no evidential basis. So there is, on the agreed facts of this case, Dr. Duval did not satisfy the conditions precedent under clause 3.19. And this is one of a number of factual inaccuracies in the respondent's written case, to which we have drawn Mr. Morey and Mr. Mallett's attention. I don't know whether they propose to address them orally, but we ask the court to please refer to the statement of facts and issues, which is the agreed position.
Can I just, on the cases, I mean, Lord Justice Lewison doesn't discuss them, probably because he knows them so well. But I mean, the striking, I mean, having been involved in at least 3 of these cases, and having dissented in at least one, it's striking what a narrow view this court has taken of implied terms. I mean, we applied a very strict test of business necessity. I mean, Arnold and Britain is the most striking example of that, which I still find quite difficult, because it's used an absurd consequence, the strict reading of the lease, and yet my colleagues thought that was right. And, well, the other Marks and Spencer probably not quite so striking, or Alley and Petroleum, but in each of them the court did take a very narrow view of the circumstances in which you should imply a term.
Well, our position would be that the law on implied terms has been relatively recently restated by this court in the Marks and Spencer's case. It's been applied since, as your Lordship indicates, in the Privy Council, in the Alley and Petroleum of Trinidad and Tobago, and in numerous other cases.
Of course, Arnold and Britain was a long residential type of lease.
Yes.
Where one might have thought there would have been quite a lot of sense in a different approach.
Yes, although the primary interest in Arnold and Britain is really as to the construction of the express terms rather than the question of implication.
Yes, of course, there again there's a great debate about whether there's any difference in practice, and again I seem to be in a minority on that one too.
My Lord, all I can say is that there is no indication from the respondents that they are seeking to overturn the decisions in Marks and Spencer's or Arnold and Britain, and indeed they rely upon So, in a sense, we are where we are, and we're simply asking you this court to apply those principles to this particular case. My ladies and lords, conscious of time, I shall take matters now very quickly, but we do say it's important And we deal with this in our written case at paragraphs 47 to 51, starting at page 93. It's important that any implied term is identified with care. We say that that hasn't been done by the Court of Appeal, and that's partly because the respondent doesn't consider the case to turn on an implied term. It's never been properly pleaded out as an implied term. But there are significant and important nuances, and some of them have been teased out in the discussion that I've been having with your lordships. So, as you know, we say there's no need for any implied term at all, that the landlord is free to grant licences before or after breaches unless and until a tenant has come forward, made a request, paid its service charge and provided security, and at which point the express terms of clause 3.19 kick in. But there's one version of an implied term which would arise only where there's a breach or threatened breach of covenant, and say in those circumstances the landlord can't take action to sanction the breach, even though no tenant has yet met the conditions of providing security and making a request. That's one version. But Mrs. Winfield, this case on its agreed facts would not have fallen into that implied term. There would be no breach of that implied term because Mrs. Winfield had not breached or threatened to breach her lease. The second version of an implied term, which is the one that the Court of Appeal essentially accepts and is therefore relied upon by the respondent, goes much further. It prohibits both an agreement which has the effect of varying the terms of the lease and preventing a breach from arising in the first place, and an agreement made after a breach has occurred, which would prevent the landlord from enforcing. It is important to identify which of those is under discussion, because the business efficacy and obviousness tests need obviously to be applied independently to those. We say neither are necessary to make these leases coherent, neither are obvious, but there are significant differences in practice, including to the outcome of this case, between the two variations. Lastly, the fifth part of my submissions shall deal briefly with why we say it isn't necessary to imply any term. We've dealt with this in our written case at paragraphs 52 to 79, starting at page 94, and I'm not going to repeat what is said there, but our argument has two key facets. Firstly, it's not necessary to imply any term because there are already sufficient existing safeguards, and clause 3.19 is not denuded of all content by the absence of an implied term. And secondly, that the implication of a term gives rise to very real practical problems which can't have been what the parties intended when they entered into these leases. So as I submitted earlier in response to a question from my Lady Black, the gist of our case is that without an implied term, there is a delicate balance here between the legitimate interests of tenants who at any particular time might want to depart from the covenants in their lease, for example, to carry out modernisation works, the tenants who may be affected by that departure, and the landlord, which has the management responsibility for the building and is itself controlled by the tenants as a body. And that balance derives from a combination of the express terms of the lease, the covenant for quiet enjoyment, the first part of clause 319, which prevents a variation where the covenant would cease to be of a similar nature, the express obligations on the landlord to repair, derives from the implied obligation of non-derogation from grant, which places important constraints on a landlord's ability to do something that would be detrimental to a tenant to whom it's granted a lease. There are common law rights in trespass and nuisance, and also the ownership of the landlord is a feature of this delicate balance, and the way in which the tenants are given an ability to have some say over what happens in their building. That results in a position where each tenant has good protections, we say, against their neighbours' activities insofar as those activities impact on their occupation of their flat or their use of the common parts. The tenant also has a say in how the building is run through its ownership of the landlord. And we accept that that doesn't give him or her an absolute ability to control what happens elsewhere in the building. But ultimately it's inappropriate for a single tenant to have such control in its capacity as tenant as opposed to in its capacity as shareholder in the landlord. And implying any term upsets that balance because it places too great a degree of control with tenants other than the one who at that particular point in time wants the licence. It enables them to prevent sensible and reasonable licences being granted to their neighbours, which would not impact in any way upon their own flat or upon their own use of the common parts. It also robs the conditions attached to the second part of clause 3.19 of their worth by removing the incentive to rational action and careful thought. It enables a tenant to make life difficult for their neighbour simply by refusing to consent to the landlord granting a licence. It also requires positive action on the part of all the tenants, which means that the landlord can't proceed in the face of silence from even one of them. We disagree with the proposition the respondent puts forward that without an implied term, clause 3.19 is left without any content. We say the first part continues to control the landlord's abilities to grant licences which have the effect of varying leases so that they don't contain covenants of a similar nature. And we say that the second part of clause 3.19 continues to permit a tenant to seek enforcement of covenants of a similar nature, even though they may not be in exactly the same form as the tenant's own covenants or in exactly the same form as when the lease was originally granted. The respondent posits two really extreme cases which it says could occur if a term were not implied. It suggests that the landlord, sorry I say it, I do apologise, Dr. Duval suggests that the landlord might sanction removal of the roof, rendering a lease valueless. But my ladies, my lords, the tenant has an express right to shelter and protection from adjoining premises. So the removal of the roof to leave a flat exposed would clearly be an interference with that easement and therefore a nuisance and a derogation from the landlord's grant. They also suggest that a landlord might sanction conversion of a flat into a nightclub. But that would clearly, we say, be a breach of the first part of clause 3.19, and it would also be a derogation from grant, breach of the covenant for quiet enjoyment, and probably also a nuisance on the part of the landlord. The respondent says that in effect our argument means that an absolute covenant like clause 2.7 is converted into a qualified covenant like clause 2.6, but that's not right. An absolute covenant which the landlord is free to vary, as long as it remains of a similar nature, remains different in kind to a qualified covenant. Obviously that's the case where statute has intervened like section 19, but even where a qualified covenant is not subject to statutory intervention, the Braganza case shows that a person with a contractual discretion does not have a completely free hand. There's likely to be some implication, such as that the decision needs to be a rational one, in the sense of all relevant considerations having been taken into account. So from the landlord's perspective, there remain good reasons for the differences between an absolute and a qualified covenant. We've dealt at length in our written case with the practical problems that we say arise, and I'm not going to dwell on those. But we do say that, in a sense, the Court of Appeal recognised the practical issues in suggesting, as it did, that a way round this was for the landlord to act in secret in the expectation that, in fact, it wouldn't be liable for substantial damages and wouldn't be made the subject of an injunction. We've set out in our argument, in our written case, why that's not a practical remedy, but more importantly, we suggest there's an error of principle here. It can't be necessary for business efficacy to introduce an implied term which is necessary to assume has to be broken in order for these leases to work for 125 years. So, my lords and ladies, for the reasons given in our written case and expanded in my oral submissions, I ask the court to allow this appeal. In the event that the appeal is dismissed, we note that the respondent doesn't now seek any relief beyond the declaration which is made by the Court of Appeal. We disagree with the explanation put forward for that, but we are grateful for the indication. Submissions after judgment on the question of costs.
Thank you very much indeed, Ms. Murphy. Well, it would be convenient to adjourn now and look forward to hearing from you, Mr. Moria.